All right, well, the fifth and final training. For those of you that have gone through the slog, we appreciate it. Thanks for coming today. If any of you have missed any prior trainings, we'll got your information. Hopefully you've seen the emails from Allison. They are recorded. If you haven't, just make sure Allison in the back has your email before you leave today, and we'll get you a link to the site where the trainings are recorded and the materials are all posted, and you can take a look at those. So just an overview first of the Greater Richmond Bar Foundation. For those of you that haven't heard it already, Greater Richmond Bar Foundation, led by Allie Fannin, our executive director there in the back, and Allison Rusi, the director of administration, who do a wonderful job. But here's just a quick overview of some of our programs, including this general counsel program. We've got the Pro Bono Clearinghouse, which is a referral service for nonprofits. We have many volunteer lawyers on our clearinghouse list, and we get requests of all types from nonprofits, local nonprofits, and try to handle anything other than litigation and farm it out to our volunteers. So it's a great resource. And for those of you that participate in this program, just to reemphasize again, that clearinghouse and all those volunteers, they are at your disposal to refer cases into the Greater Richmond Bar Foundation. We're hoping that this program and the clearinghouse will work very closely together to get any issues that you spot in your role as general counsel with these nonprofits that you're matched with, farm it out to the clearinghouse, and we'll get those solved, hopefully. The Pro Bono Promise, again, if you or your firm have not signed on, or your corporate in-house program have not signed on, you can learn more about it, but it's basically the promise to, achieve our aspirational goal of attorneys of 2% of our time dedicated to pro bono, and it talks about trying to have a policy in order to strive for that, and Allie or Allison can get you more information on that. We also work on the Veterans Initiative and Justice Server 2.0 and Triage. You'll hear more about Justice Server later from Allie, but Triage, for those of you that maybe haven't heard about it, is a new program that we're setting up to a ring around CVLAS. Is that the official Scott Osteich definition of the second ring? Okay. We're not going to go to all the rings of Saturn, but we are going to set up a second ring around CVLAS. And what that does, so you know, and if you talk to people, we're trying to identify certain areas of law where the private bar can step up and take some cases off of the workload of CVLAS and farm those out. So if it's something you want to learn more about, please reach out, let us know. And you've got the website link there. Overview of the GC program. I think you guys have already probably heard this and many times for those of you that have been to the other trainings. But again, we are in the process of reviewing. We got almost 30 applications from nonprofit organizations, and we're going through those, and our task force has gone through those, and we hope to match between 15 or 20 nonprofit organizations with a volunteer attorney to be their GC volunteer starting January 1, running through December 31 of 2018 to serve as issue spotters, to serve as to overview and review their corporate documents, to provide a legal resource to them to help identify issues and refer those issues out to the clearinghouse or otherwise. Just process-wise, again, I'd say hopefully by Thanksgiving, before Thanksgiving, you all should see a survey or a link to take a survey from Allison or from us. And what we're going to do with that is kind of let you guys know the types of organizations that we're looking at, the 15 or 20, and it's going to be kind of an interest survey, just so that as we do the match, we can try to align interests as best that we can, as best that it'll work out. And then I would say, hopefully, a couple weeks after that survey, we'll have the matches out, so you'll know if you've got a match for this year and who that would be. And if there are volunteers that we're not able to match with a nonprofit organization for this year, we hope that you'll stay in the program, and we hope to have another class next year and the year after. So we'll keep it going. If you are matched with the program for this year, we do ask that you watch any of the videos and review any materials from any of the trainings that you missed by December 31st. So there'll be some more communication and documentation on that front. And with that, I'll turn it over to our presenters for today, Chris Malone and Zach Cohen. Thanks, guys.
Good morning, folks. I'm glad to be here this morning. First of all, thank you all for your time and your commitment to this new effort we're trying to kick off here in Richmond. It's part of a process. It's the end of a dream that we began with the Pro Bono Clearinghouse years ago, and now to augment that opportunity by providing the opportunity for individual organizations to have a general counsel, outhouse general counsel relationship is kind of neat. I know that in the nonprofit community, the organizations I've spoken to are pretty excited about this. They're looking forward to the benefit that they'll get from this program. Our job today is sort of to be the cleanup hitters and kind of talk a little bit more about the practical aspects, the day-to-day realities of operating a nonprofit and serving as counsel to nonprofit. By way of history, I began my career in 1981 in private practice, and in 1982 there was a crisis in Richmond with respect to dealing with the needs of the homeless. And it all showed up in my office. So all the organizations that were being formed at that time, Freedom House and Caritas and all those others, the people found their way to me. So my introduction to nonprofit formation and nonprofit entity management began in response to a crisis in Richmond. And I've been privileged for many, many years now to work with a lot of small to medium-sized nonprofits. My focus is really going to be on those nonprofits that most of us will probably be joined up with, okay? The much larger nonprofits normally will have a general counsel relationship that they're going to rely upon. So we're going to be looking most likely to the smaller nonprofits that will be asking questions and needing some guidance throughout the year. And my goal today is really to show you some places that we might want to be prepared to run some checklist about and make sure that if you're in that general counsel relationship, you'll have the opportunity to be a good servant to them and helping them to avoid some of the pratfalls that can occur for nonprofits. So I'm going to begin my conversation with the assumption that good things have happened, and that is that the entity has already been formed. That's already secured its tax-exempt status. I know you've already had a lot of conversation about how one goes about that. I want to talk a little more about sort of the annual events that we need to look at, keeping in mind that your tax-exempt status, once secured, is something that has to be maintained, okay? And the way we maintain that tax-exempt status involves a number of things. One thing is not on the slide, though, and I would recommend generally, my general rule with nonprofits is if you're going to have a relationship as a lawyer with a nonprofit, whether it's general counsel or otherwise, make sure that you're the registered agent for that entity, okay? First hint, always be the registered agent. Because I can't tell you how many nonprofits they name an officer their registered agent, and that officer rolls off the board, and the mail goes to the wrong place, and they don't file their annual reports, and suddenly they're no longer in business under Virginia law. And 2 years, 3 years pass, and suddenly they say, well, what the heck? So first of all, if you don't mind being registered agents, it's a small effort. It's probably one of the most valuable things we can do for nonprofits, because annually we know that there's going to be a moment where we're going to be alerted to checking with them about the things that they need to be doing to maintain their corporate status, first of all. And that is to file that annual report to make sure they've got their officers properly elected, to make sure they've identified their board. So while not on the slides, I start there. Make sure, if you're willing, it's a small task for us as lawyers, but a great benefit to the particular nonprofits. We do that. On maintaining tax-exempt status while operating, I've talked a little bit about the annual tax filing requirements, and I just want to break down what the differences are. In the documents I think were sent to you by email, I attached copies of 990s and 990 EZs and things like that. Here's the deal: if a nonprofit generates more than $200,000 in income or has more than $500,000 in assets, it has to file a 990 annually. 990 is a long form, right? If it has less than $200,000 in donations in a year, and less than $500,000 in retained assets, it can file a 990 EZ, which is a much shorter form. Many nonprofits, a significantly high percentage of nonprofits actually generate less than $50,000 a year in income. If they have less than $50,000 a year in income, they can file what's called the 990N. It's basically a postcard. All they have to do, it's the simplest thing to do, but it has to be done. Because if you fail to do that, eventually, you're going to get a letter, as did one of the nonprofits that I helped set up recently, saying, guess what? You've now lost your 501c3 status. It's that 501c3 status will be terminated effective as of the date of non-filing. You can reinstate fortunately, but you pay a new fee to file a new application, and you have a gap in terms of deductibility of your donations, unless you do it immediately. There's a procedure that allows you to make it retroactive to the termination date. But for us as lawyers, the one thing we want to make sure we ask these people is, have you done your 990s, 990EZ, or your 990N, and verify they've done it. Okay. I suggest also that one of the things we can do to help with this is to help, if you're going to be in this general counsel relationship, help build a calendar. We'll call the legal dates calendar for your entities. We know that your annual report with State Corporation Commission needs to be filed by such and such a date. Create ticklers for them. That your 990 is going to need to be filed by May 15th. We tickle that for them. Send them the note and say, don't forget. But it's a great benefit to particularly small nonprofits to have this kind of calendar of events to watch, okay? And for us as lawyers to be tickling those things. When you get contact, say, hey, it's April 15th. Have you done that yet? It just helps. Lots of times nonprofits, and sometimes without benefit of counsel, are going to try to amend their articles of incorporation. If they amend their articles of incorporation to change their name or to change their purpose or to change any significant portion of their operating entity documents, they need to consider whether or not the next time they file their 990 or 990EZ, they're going to have to file a copy of those amendments, okay? So whenever you're looking at amendments to articles of incorporation and potentially some bylaws amendments, you're going to have to be very careful to make sure that if there's a requirement for additional filing when they file their next information returns with the IRS, that they'll go ahead and do that. Does that make sense? So I'm just trying to hit things that I think come up for us normally as we're working with nonprofits. Again, assumed name filing, Zach is going to talk a little further about that later on, but a lot of our nonprofits are create programs that are specific to their entity, and they'll start operating. It'll be the Open Door Shelter program operated by Caritas Inc. Well, if they're trading under that assumed name again, this is something that we want to make sure that they've properly protected themselves by filing the appropriate assumed names where that's necessary. So just some early things. Zach, you want to hit the next one? I know you all had an early introduction to the requirements for filing with the Department of Agriculture and Consumer Services for a solicitation permit in Virginia, and I know we've already covered that once, but I just want to reaffirm how important that is. Failure to do so is problematic. I have had an entity that ran into a great deal of difficulty with the state by trying to do solicitations in Virginia without having the appropriate permit. If you look at 5757 and et sec, which are the statutes regarding 5749, et sec, the statutes regarding the requirement for a solicitation permit in Virginia, the penalties are fairly unforgiving. I'll just tell you that. And when the Attorney General's office gets involved and they determine they're going to have to act, it is very problematic. So making sure that where required, our entities that we're working with have an appropriate solicitation permit, which again should be on that calendar for renewal each year. It's an annual renewal. Practically what we do is we file the application, but we also have to file annually a copy of your 990, 990EZ, or 990N. All have to be at the state in order to stay in compliance, right? So we have to make sure we do that. That's another one that I would really say is a great tickler item, a great calendar item for us to try to follow. This little tickler here about it, fundraising plans and programs are compliant with IRS and state guidelines. You'll be amazed how many great ideas people have about new and interesting ways to raise money. Lotteries, lots of law about that, folks. We got to be careful about how we structure those things. Auctions, fairly safe. Consignments. If people say, we'll give you this vehicle and we're going to give you the vehicle and you'll pay us $10,000 and anything over and above that you raise is going to be yours, you got to make sure we understand what the arrangement is there. We got to make sure that we vetted the contract and figured out. Bingo is a total exception to anything I'm going to talk about today. Lots of folks say, let's do bingo. If you say, let's do bingo, and you don't comply with the law, and there's a great deal of requirements for being qualified to run a bingo game, I just tell you, if somebody says bingo, leave the room, unless you're really interested in doing an awful lot of research. But it's just one of those things. Oh, yeah, great idea. It's not always a great idea. And my hope is that in our position in general counsel, we're going to be able to say to people, run those things by us. Most of them will be fine, but sometimes there's some special statutory provisions that are going to make that problematic, and we have to be careful about this. This last line here, be wary of joint venture fundraising. And I want to give a little practical example on this one. A nonprofit here in town was approached by a business in town, and they said, look, we'll do one of these joint venture fundraising things with you. We'll donate X, and it's a very attractive item that people will want. And we'll sell tickets, and you sell tickets, and we'll do the drawing for who wins this thing at our facility. It'll be all great and wonderful. And so what are the problems with that? What are the practical problems, okay? How do we know where the tickets are? That was the problem here, okay? The folks, hundreds and hundreds of tickets were sold. The event took place. All the tickets were put in the right place, they thought. And the person was drawn. And 2 hours later, from another location of this business, they came in with 600 additional tickets. Yikes. So my point of concern here is, if you're doing anything with anybody else, you got to make sure that we're in control completely. If chasing the tickets, whenever you're doing any kind of these lotteries or auction things, and you've got people other than your principal operating folks selling tickets or selling whatever you're selling. If it's going to be any kind of a drawing type event, you got to make sure you get everything back before you do it. Because in that case, we had a real problem. We had 600 people who had made a donation by taking a chance, who weren't included in the drawing. Yikes, what do? Do you contact 600 people and give them their $10 back? Do you tell the person who won, we got to put your name back in and we'll try again? Very problematic thing. So I just say this is a really practical issue that I tell you comes up. When people are doing this, it's good for us as lawyers to say, okay, now let's walk through this. How are we going to protect and make sure that when this happens, it happens properly? I don't mean to dance on the head of a pin, but that's a concern when we're working with nonprofits on a day-to-day basis. Obviously, the objective of a board, a properly formed board for a nonprofit, is to generate money to support the mission of the organization, and they'll come up with lots of different ideas. Can we take this donated real estate? Oh, yikes! All those things that we have to look at when we're offered opportunities. I just tell you are very important. We talk about formation of contracts with nonprofits. Another issue that I think is a practical concern as we go forward with the operating entity. Who is authorized to bind the entity? Presumptively, based on the organization, if it's a corporation or an association, it's going to have identified officers. But what's their authority to bind the entity? Well, we have to establish that. We're going to have to establish that somehow by an appropriate resolution or a guidance given by action by the entity at some point in time. Presumptively, the officers can do that. They can act on behalf of the entity by virtue of their title under Virginia law. But it's certainly not convenient for an officer to have to sign every document. Can an executive director sign a document? Interesting question. Without authority, they don't have authority to bind the entity. So we have to look at that. So one of the things that talk about is on contract side, you're probably going to need to be careful to make sure we've got appropriate resolutions in place to confirm who has the authority and what the limitations of their authority are. And there may be an appropriate resolution that says that if the contract is going to be in excess of $5,000, then it has to be signed by a board member or two board members, period. But we can give the executive director some limited authority. This concern to me all goes back to, we're fiduciaries of the funds given to us, so we have to make sure that we properly manage them. So on the contract formation side, just be careful. It can be burdensome, particularly with small nonprofits. I'd sort of say the smaller they are, the more control I'd like to have the officers to have on things like that. In the early days of a nonprofit, it's not so much to say, okay, well, bring me the contract, I'll read it, I'll sign it when I'm sure, rather than saying having the executive director just have authority to do things. The smaller the funds are that you have, the more concern I have about making sure that we're properly managing those funds. So you're going to want to look at that and look at how the entity has decided to deal with this issue and what authority has been given properly, and making sure that authority is being followed in terms of the actual execution of contracts. Obviously, review of contracts, we're lawyers, we review contracts all the time. I don't think you need to review every contract that your entity is going to be involved with, but certainly that's another opportunity for us as counsel to say, okay, if it's a significant thing, certainly a lease, I always say, let me see the lease. If it's going to be a purchase of real estate, yeah, if it's a long-term commitment, we're going to want to look at those things. But the real issue is who's got the authority to make this happen. The last thing there is, make sure there's an annual resolution deciding who can sign contracts. Again, we have changes in board membership, we have changes in staff, we have changes in, just make sure we're making sure we keep current on that, so that we don't have an authorization out there that says Mary Smith is authorized to act for us and she hadn't been an employee in 4 years. But these are just things that can be problematic. Go ahead, Si. I talked before about there might be some limitation on signing authority. You give the specific dollar amount or a particular term, like a term, 6 months, a year commitment or something. The next one is sort of optional. It really focuses more on the smaller the nonprofit. The smaller the nonprofit is, the more I want other eyes to be seen on contracts. As a nonprofit becomes a little more mature, we could probably let go of that. But in the early stages, particularly, we want to look at everything if possible. Creation of forms of purchase orders, contracts, et cetera. A lot of your nonprofits are going to have programs that are ongoing, and commonly they'll create forms that they use for the operation of those programs, and I just recommend that we look at them very closely. We have a lot of nonprofits that are involved in the human services field, okay, and they gather information, and they do applications, and they ask questions. And we have to look at those applications for services and things like that and say, okay, well, have we got any problems potentially with this? What information are we gathering? If we're gathering HIPAA-protected information, we've got to protect it. If we're gathering Social Security information, we need to protect it. We need to know how what is fair for us to ask, and how we're going to comply with the statutes that apply to everybody, and nonprofits and otherwise, when we undertake to gather this type of information. Okay, I'll amplify this when you talk about employment. On the employment side, I know you had a session on employment, but again, we have to look at the employment applications. We have to look at what's being gathered, and I'm sure everybody here knows. The hot issue now is, for all of us lawyers, you can't ask people what their past salary was. That's becoming the new wave. That was traditional. We'd always ask that question, but things like that we probably want to be somewhat wary of, and say, hey, if you're going to set up a new program, let us see what your application is going to look like. Let us see what type of information you're going to gather. And if you're running a program that gathers any of this protected information, making darn sure that we're compliant. It is certainly the case that nonprofits do get sued over this stuff. So we want to try to help them to do the best they can to meet those expectations. Make sense? I'm not trying to overwhelm. I'm just trying to put some things out there that long, hard experience has taught me over the years. And it's terrifying when, as a lawyer, you're at the meeting and they hand you something, you say, oh my gosh, how long have we been using this? So if you can get in front of it, it's a little better. Go ahead, Zach. This is another issue that is very, very common issue with our nonprofits. There's a signatory authority on deposit accounts on an ongoing basis. Annually, we reelect officers, we reelect directors and stuff like that. Well, you got to have an annual resolution. If you had a change in officers, you're going to need to take care of that every year to say who now has authority, and you got to go through the deal of getting to the bank and changing the signature cards and all that stuff. And if you have employees who are going to be authorized to sign for you, I have a strong bias in favor of making sure that maybe we alternate that designation unless it's a long-time trusted employee over the years. Obviously, this is something we all do in our business. We make same recommendation. You know, if you want to protect yourself, make sure we require 2 signatures on checks for larger amounts, okay? And we can certainly do that by resolution with the bank, and they'll be happy to honor that for us. But it's important, particularly, you know, like any organization, you know, any for-profit corporations, entities deal with the difficulties of embezzlement and employee theft. Nonprofits, we have the same problem. So we have to do all these things to make sure that we're protecting ourselves on that. Zach? Simple thing, just procedurally. Monthly checking, savings, investment, payroll account statements. For God's sake, make them come in paper. Make sure we get paper copies, okay? You know, again, I'm shocked by the ability of people to manipulate things on computers these days. But you know, if people want to embezzle from you, they can manipulate those digital account statements, and everything will look fine. It comes digitally, but it's been altered. So I always say, if you're in a nonprofit, let's pay the extra fee to get returned checks and statements so we can look at them. I'm a real big believer that with respect to where those statements go, and I sound a little conservative on this, but it's for real. I would never let a person who has signing authority be the one that receives the statements, okay? Particularly in a nonprofit, okay? You can have them go to the president's house, I mean, well, not, you know, somebody other than the person who day-to-day has signing authority. It helps make sure that we've got some other eyes that are always going to be on that statement. And of course, like lawyers, everybody else should do monthly reconciliations of those accounts and make sure that we get a chance to see them. Fidelity bonds, employee dishonesty bonds. I think nonprofits have an absolute responsibility to make sure that they're in place, to make sure that we're not, you know, again, we're fiduciaries of the funds we have, so let's make sure that we have those in place to protect as best we can within the limits of our capacity to pay for them, but to make sure that we have those in place so that we're not going to suffer a loss if there is an embezzlement. Review internal financial controls. You know, we're not accountants, but you know, we ought to ask some questions now and again and really kick down to the next one, and that is, you know, even with the smallest nonprofit, and there are great resources here in this community, the accountants are just as committed to helping nonprofits as we are. You know, you can get a negotiated fee for a limited audit, but we ought to do it. We ought to have somebody's eyes looking at even the smallest of our nonprofits at least every 2 years, I think. Just a practical thing to say, okay, guys, let's make sure we're doing this right. It takes a lot of responsibility off the board to know that that's been done. Make sense? Okay. Most of our nonprofits, particularly those that are human services agencies, have petty cash accounts that are made available at the office to address what they call at-the-door needs. When somebody comes up, they've got an emergency. A lot of times we'll have a credit card that's made available for emergency purchases. Again, you know, the whole document issue. We got to chase that money. You know, it's not, well, we've got that $200 that started out the month at the desk, and now we've got $8 and we must have given it out. Again, just a caution that I would throw to you. Nonprofits regularly receive restricted funds. Everybody understands we're talking about restricted funds. Somebody will make a donation and say, this is my special donation in honor of my son, and it's to be used for, name that thing. If that used for is consistent with our mission and we accept the funds, then we have to restrict those funds and make sure that they're used exclusively for that purpose unless we get consent from the donor to modify that purpose. And this can be problematic. You know, it can be problematic if your mission begins to change, if your focus of your services change, and that money was given for this purpose, and you want to modify it. Well, you know, we've got to go back. We really do have a responsibility to go back and get some relief from that, or agreement from the donor to modify our use of those funds. Reporting to donors of restricted funds. You know, lots of times donor letters will come with, you know, please give me an annual report of what happened, how you've used the money. Again, I encourage you to make sure that when we take funds on that basis, we look closely at those donor gift letters. And if they say we'd like an annual summary of how the funds have been spent, well, that's a condition of the gift. We have to meet that obligation. In terms of fundraising, it would be insane not to do it. But just in terms of the practical side of things, I just encourage you to be aware of that and make sure that we comply with those donor requests. Any questions at this point? I'm kind of moving along fast. We okay? Is this making sense? Okay. General solicitations, we go back to Virginia law here. I know that you all had the conversation about this before, but if we've gotten a solicitation permit from Virginia and we make a solicitation in Virginia, we're supposed to have that little catch line. I'm sure they talked about it. It's got to be at the bottom of anything any public request for donations that we're listed with the Department of Agriculture and Consumer Services. A Form 990 can be seen there. That's supposed to be on every fundraising request we make if we're required to have a solicitation permit in Virginia. I would suggest to you, I think 95% don't. But I just encourage you to look at that. Recognition of donations, the IRS says more than $250, we have to be prepared at the end of the year to give a statement. Under our solicitation rules in Virginia, it's $5. If you receive more than $5 and the donor requests a statement, you have to give them one. Okay, so another one of those things that is out there that we just have to be prepared to comply with. All these things are, the Virginia statute is probably only 10 pages long. I just encourage you to look at it because there's a lot of nuggets and a lot of terror built into that statute that we ought to be aware with. Giving level recognitions, we as nonprofits, we're always hoping that we can publish annually who's done what. Again, that giving level, where are we? Yeah, go the other way. The giving level recognitions, first of all, we've got to have consent from donors to publish their names. Okay, so make sure that when we're receiving that donation, that we create that form. That check should be on there. Do we have your consent to publish your name? That's important. We can't willy-nilly just do that. So I encourage you to be sure that if we're going to be publishing things, if we're going to be doing particularly the giving level recognition thing, is not so much a legal thing as it is a fundraising thing. If people are not aware that there are levels of donation recognition, and you don't tell them that, and they give $249, and if $250 they'd be called a Lee Bird giver. It's just nice to let them know that. Okay, so when we're doing that, make sure that the materials that go out to make the request for donation reflect those things. Statement of value of goods received. Another issue we need to be clear with. If you have your annual meeting and it's a dinner and it's $75 a seat, well, we have to tell them what portion of that, if any, is going to be deemed deductible for purposes of taxes. Okay, so $75 a seat, there's nowhere in town that you have anything deductible, I don't think. But if it's $250 a seat, somewhere you need to say on that ticket that $75 is the cost of the meal and only $175 is deductible. So we have to be looking at those things. And these are just, this is not our job to make the decision, but it is our job to ask the question as we go along. So I encourage people to look at that. Another one of my favorites here is specific purpose solicitations. We've all seen them on television. We've all probably seen them in the mail that we've gotten. For $10 a day, you can. Well, if you do a $10 a day donation and the gift is given in response to that, first of all, in my view, that's a restricted donation. So if somebody comes back and says, I want to sponsor a child, and you've said, well, $350 you can sponsor a child, that can't be used to pay the rent, I don't think. So we got to be careful about how we're defining these things. This evidence must be available to support the funding level request. If you say for $10 a day you can, and somebody asks us that question after they've made their donation, we have to be able to verify that, in fact, that can happen, and that we have the resources to do it, and we're going to devote those funds to that purpose. Make sense? Naming opportunities, just another one of those fundraising tools that people use. If you give us $50,000, we'll name the whatever after you. Again, naming opportunities are a great resource. Let's make sure we have a contract that defines what they're going to get in response to that level of a donation, and what commitment we're going to make to them to continue that name going forward. If it's the 20F conference room at Hunt and Williams is now going to be called the Fred Golden conference room, and we move the offices, well, what's going to happen? What are we going to do? So we have to make sure we're clear about what commitments we're making, even if we take a naming opportunity gift. Does that, again, make sense? Okay. Obviously, nonprofits are famous for wanting to do special event fundraisers. If we're going somewhere else, we're going even if it's to a church. We got to start ticking off these questions. Who's got insurance? If we're going to be doing an event, we have general liability insurance as a nonprofit. If we're doing an event at Third Baptist, we have to find out whose insurance is going to cover the slip and fall and things like that, and make sure we're covered. It's just a matter we ought to look at. Okay. Zoning restrictions. If we're going to do an event out at somebody's farm and we're going to bring 500 people out there, well, can we legally do that? What type of special event permit might we need from the county? What type of catering license might we need to do something there? And this last one I really want to kind of say, accessibility. That's really an issue for us as any entity running an event. Nonprofits, if we invite our donors to come and we don't have an accessible venue, we've got a potential problem as well. Okay, so just practical things, things we should tick off. My goal in trying to create this list was not to scare people. You say, okay, just checklist of things to think about when these things come up. Obviously, food and beverage issues. If you're going to have an event that is a ticketed event, you're going to serve alcohol, we have to have an ABC license, a special event license, period. Okay, not hard to get. Yes?
I have the impression that a lot of charities try to raise money by conducting a wine auction.
Oh, yeah. Yeah, you're an expert on this talk.
It's very difficult to lawfully conduct a wine auction. So I think it would be a really good idea to seek some advice from the ABC board, try to find a retail licensee who's willing to, in effect, be the place where the auction occurs and donate its profit to the charity.
All the above. Thanks, Paul. That's the prime example of the type of things that come up. Seems like a great idea. Let's do it, and we'll do it in the church basement. Yeah, not so much. So we got to be careful about that one. But that's a good point. Catering license insurance. I talked about that briefly. But the ABC license is another one that people miss widely on. And suddenly you're out there and you're serving alcohol, and somebody says, "Well, where's your license?" Yikes! So it's very simple to get, but easy to forget. So I ask you to be careful about that. Want to go to the next one? Bake sales. Sale of food and beverage events or as a fundraiser. The whole homemade goods area has created a whole new challenge. If you're going to have that table of cakes to sell at the bake sale, well, we now have allergy issues, food safety issues, all those things. If it's being sold under our name, to the extent there's a problem, we've got liability. I don't mean to be hyper silly about this, but if again, it's just an area where we have to be a little anxious to say, we should be careful about those type of events. Make sure that whatever insurance we have is going to cover foodborne problems. If we're going to be having a cake, we make sure that cake contains peanuts. It says gluten-free if it is or not. I mean, it sounds crazy, but these are real issues that affect nonprofits. Because somebody calls 3 days later and say, I've been sick for 3 days. What in the world did you serve me? What in the world? Why didn't it say, my child's in the hospital because of a reaction? We just have to recognize that as nonprofits, we've got that exposure. I've talked about this briefly before. Recognition and awards. Sometimes we'll want to honor somebody, and we'll ask them to show up at an event, and we won't have told them that they're now going to be our big award honoree, and we've duped a lot of people into coming in their honor, and they don't even know about it. And they paid a big fee to get in to say, congratulations, Mike Goldman, you're a great guy. you really need to make sure that you've got that person's consent before you do it. Again, I'm not so sure it's exclusively a legal issue, but it is certainly a fundraising issue and a business issue we got to be careful about, because I have seen that happen where a person who's a tireless supporter of an organization wants nothing more than to be a supporter and doesn't want to be pushed to the front of the room for any purpose. You can damage your organization by doing that improperly. Whether there's an exposure or not, Zach will talk to us later about the inappropriateness of using somebody's image or something else without their consent, but be careful about that, okay? How's my time here? Okay. In terms of investment in nonprofit entity funds, again, I've said a couple times, we're trustees, we're the fiduciaries with respect to those funds. I think we should always have an investment policy if we're moving along the chain here. Once your organization gets to a point where it's got sufficient funds that it doesn't need those funds on a daily basis for operations, and we've got excess funds, immediately at that point we got to know what our plan is and how we're going to invest those funds. And it really there should be a stated investment policy that's reviewed and approved on a regular basis. Now, if it's $25,000, well, we're going to leave it in the bank and we'll make 0.5% or 1%, whatever. But if it continues to grow, then at that point in time, we've really got to move down the train and start to come up with a well-vetted and well-approved investment policy. And the next slide would tell you that I believe you should, it's not always a good idea for the board to think by committee it can do this, it can manage this. So when you get to the point where you're having significant funds over and above the amount of funds to protect an FDIC deposit protection, I'd say at that point in time you need to have a third-party advisor. Put those funds in somebody else's hands. And why? Because if they're wrong, we got a shot. If we're wrong, we've got none. So, let's get it over there. The overconcentration issue does become a problem. I work with a nonprofit in Chesterfield that has been around for a long, long time. We have the benefit, it's a public-private partnership, and what we do is we create housing stock for disabled folks in the county. And what we do is we through use of federal mortgage loan funding and other things, we're able to purchase houses, renovate them, and then we lease them essentially to the County Community Services Board. Great idea. Well, over the years, because of the success we've had with that, and we've got like $1.5 million in cash. A lot of it's required reserves for maintenance and things like that. And imagine my horror when I found that all those monies were in one account at one institution, in a single account. First of all, they should have been invested, but secondly, way beyond FDIC deposit limit protection. So, again, just something to, when you look at the financial statement, say, okay, $470,000, where is it? Where is that money today? Because if it's all in one place, not that I think we're going to have a bank crisis, but the optics are much better, particularly as we move further along the chain and start getting foundation grant possibilities and things like that. When they look at your financial statements, it helps them to say, okay, they diversified the investments. That's great. They're looking at whether you're a good risk or not for their foundation grant. They're going to be wanting to see that you've got these type of things lined up properly so that there's not going to be a problem. Are these things somewhat helpful, folks? You doing all right? Okay. Annual governance and board membership issues, and this is really where lawyers, I think, general counsel, that this program will be very helpful. In my experience, it is very common for nonprofits to, particularly smaller nonprofits, to say in their bylaws that we'll have 12 members on our board. The board should be composed of 12 members, 2 of whom shall be from this, and 2 of whom shall be from that, and 3 of whom shall be from here, and so on and so forth. That's very common, particularly when the nonprofit has been formed as a derivative agency from perhaps a collaboration of churches or something else. They'll want to have membership. Well, we're going to have 2 from our board and 2 from your, 2 from our trustees. But if that's in the bylaws, that's got to be honored. Okay, we got to find a way to make sure that when we create our slate of potential nominees for the board, that we have the right mix of nominees to meet those requirements. Because if they're in the bylaws and we're not complying with that, we don't have a validly organized board in my mind. Okay, so unless you amend the bylaws to get out of that, you've got to be careful about that. So that's the special constituency seats on the board. Obviously, there ought to be a nominating committee. That's just a small hint, but make sure we've got a year-round nominating committee on every organization. I'm shocked how many boards of nonprofits have no idea what people's terms are. Again, it's an affinity connection. People, they'll stay as long as they're allowed to. But one thing we can ask as general counsel is, okay, show me your board, show me your terms, show me when we should be expecting people to roll off, and look at that and make sure that that's used as guidance annually when it comes to the point of trying to do your annual meeting and your annual election of members of boards. Good. I'll disclose another one of my biases, from a drafting standpoint. If you're at the front end of creating articles of incorporation for any nonprofit, I just have a strong bias in favor of who can be members, okay? Again, a little practical experience. There are a number of entities I've worked with over the years that tend to be church-related. And let's say that any person who makes a donation of time or talent to the organization shall be a member. Now, you tell me how you're going to send a notice of an annual meeting. It's a very practical, but it's a very real problem. How can you have a valid annual meeting unless somehow you've created a sign-in sheet or a roster to find out who all those members could be? My bias is, and every time I get a chance to draft articles of incorporation for a nonprofit, I say the members of the organization shall be those duly elected as members of the board of directors from time to time. You can have a real quick membership meeting that way. If you expand you can have non-voting members beyond that. But in terms of being able to take corporate action that requires a vote of members, be very, very careful about who the members are. It is a very common problem with nonprofits that because of the desire to create that affinity connection, the desire to recognize their donations, we're going to say you're a member. Well, hello. Be careful about that. Membership fees, you could become a member of. If you're charging membership fees, then those persons are entitled to a meeting notice if you're going to have an annual meeting to do things like this. So it's just another area where you look at your bylaws, look at your articles of incorporation, find out if we're going to have an annual meeting, who we got to invite. If the organization is strident in saying, no, we really do mean we want the open tent, then we have to help them find a way to make sure they've done a good job to give notice. And what's the final default? Page C3 of the classified section. You do the public notification. You can cover yourself that way. But you also have the problem when you look at your bylaws and say, what quorum is required for a meeting. If you've made the whole world members, how do you establish a quorum? So these are very practical issues that come up. They probably don't come up that commonly as somebody challenging them, but from a legal perspective, they do come up, okay? So I just encourage you to be sure we're clear about who the members are, how we give them notice, and how we can take action. Terms being voted on, this whole issue of staggered terms and things like that, just make sure we know if we've got a slot of 4 people being elected, what terms they're being elected for, and how we're going to determine who's been elected to what term. Another thing that comes up, well, I got elected, I thought it was a 4-year term. No, actually, we elected 4 people, 1, 2, 3, 4. You got to be clear about what those terms are going to be. As lawyers, we need to help advise people about how the voting procedures are going to be conducted for the meeting. Are we going to vote on an individual basis? Are we going to vote by slate? How are we going to do it? And how are we going to make those motions to deal with those things? And of course, the most important place for your minutes is your annual meeting. Make sure that your annual meeting minutes reflect the actions taken properly, so that we can ensure, not only for the optics internally but externally, again, fundraising fund sources sometimes want to see these things. And if you don't have this stuff available and they say, we'd like to make a grant to you, let me see your last annual meeting minutes, important to have that, okay? Zach? And what do you do with the circumstance when you have, a board member who says, I've got to resign? That's great. We can't just elect somebody unless we've somehow got authority in the bylaws to do that. So just, again, another issue. Can we put somebody in his or her place? They say Joe will serve. Well, unless we've got the authority at the board level to do that before the next annual meeting, we just can't willy-nilly be adding board members, okay? Nonprofit board bylaws almost, unanimously, we'll have some provision in there that says that if you fail to attend 3 successive meetings, we can remove you. Make sure that you can verify that that's happened, if any actions can be taken to remove people. My experience with nonprofit boards is sometimes there's a difference of opinion as to the future, and people start playing around with you saying, well, he or she missed 3 board meetings and I want them off. Well, you got to have evidence of that, and if the board is going to take that action. Another thing that's very common, of course, is advisory boards. Lots of nonprofits want to have an advisory board. First of all, you got to have authority for it, in my view, in your bylaws to establish an advisory board. So you want to make sure that you've got that advisory board properly authorized. Same things apply as always. We sometimes say, well, we're going to create an advisory board, and we don't really have any terms for them. We just want to use their name. No, we should have terms. We should be clear about what their term is going to be. We should always be very clear about what their purpose is. There's got to be some definition as to what that advisory board's responsibilities, authorities, or expectations are going to be. It is, again, almost unanimously common that nonprofits will want to get supporters who don't want to be actively involved in their organization but want to use their names because they're big community names or something else, and they'll create this advisory board. But we got to know what its purpose is. It's got 2 problems if you don't know what the purpose is. One is if they're your big fund supporters and you've asked them to do something, you don't give them anything to do, you're going to distract them from your mission. And the other thing too is if you create an advisory board and they think they're supposed to be doing something and you don't let them, then you've created a diversion from mission. So I just say let's be careful about that. In the package of documents that I think were emailed to you last night, there's a bunch of stuff, bunch of forms and things like that were attached. I included a conflict of interest certification and confidentiality certifications. Every board, I think, should annually do this, okay? There's a conflict of interest form that needs to be signed by every board member saying, look, I acknowledge that I can't engage in a conflict of interest transaction with respect to the board without appropriate board action. So they acknowledge that and say, okay, I sign off, I've got it. For us as lawyers who sit on boards, it does happen all the time. You're on the board and they say, hey, we need help with, can you do it? And if that ever, whether it's a fee-based representation or not, that could be a problem. Because of our duties with respect to conflict of interest as members of boards of directors and nonprofits. So if we're going to be in that position, we just got to be sure that we've signed the conflict of interest, and if we're going to be acting inconsistently with that, we have to get board approval to do it, okay? Confidentiality certifications, again, I think it's just important that we clarify with our board members that what happens in the House stays in the House unless we decide we're going to make it public. It's nice to make sure, particularly on the human services side agencies, to make sure that we've got a confidentiality certification for people, because occasionally in an executive director presentation or something, we're going to be getting otherwise statutorily protected information. So we want to make sure that people have signed that confidentiality certification. Again, there's a form for that was in the package. I'll confess, it's probably from St. Gertrude's High School because I'm on their board, but it's a well-done one. I think it was one of the better ones I'd seen. The whole question about executive sessions and when can we call it and who's present. Lots of times when the heat in the room gets a little tough, somebody says, let's go into executive session. I want everybody out of here except. If we're going to go into executive session, we have to have a reason for it, okay? Sometimes you can have a bylaw provision that says that the following matters shall be resolved only in executive session of the board. What does executive session mean? Well, first of all, who's going to be present? Customarily when you go to executive session, no staff or employees are going to be present. This is going to be exclusively board, unless somebody is requested to come to speak on a particular issue. What are the type of things you're going to have executive session? Obviously, personnel matters. I think there always should be executive session. Potential actual litigation, obviously. Major new policies or programs, I think they're good. And sometimes, a contract needs executive session discussion where your executive director said, I think this is really a great idea, and I recommend we sign this tomorrow, and the board has just been presented with this. You say, no, thank you very much. We'll discuss that amongst ourselves, and we'll get back to you as whether or not we're going to do it. So it gives you, when you want the board as a whole to look at something like that, you can do that. Public participation in board meetings, another question. you gotta be clear about what is the door open or not. If the door to your room is open for a board meeting and 3 people come in and sit down, you got to have a plan for what you're going to deal with and what their role can be in that meeting and how they can participate or not. Okay, and this happens. Anybody had that one happen to you? Yeah, it'll happen. Suddenly, somebody's there who wants to show you their tonsils for about an hour. They've got something under their burr, and they can take over your board meeting because they say, "I want to complain about," and so you can't throw them out if you don't have a policy. I don't mean to say, I'm not trying to be harsh here, but you got to know what your policy is. If somebody comes in and says, I'd like to speak to the board, you say, okay, fine, call me and we'll give you 5 minutes on our next meeting, rather than people just showing up and trying to hijack your board meeting, which can happen. Okay, so be careful about that when you're out there. And again, a bylaw provision will help with that. A standing policy will help with that. It is very difficult in the moment to get your board to have the wisdom amongst themselves for somebody to make a motion to close the meeting. So if you have the policy ahead of time and they know what it is, it's a good thing. In terms of standing committees, I just suggested these are a number of committees you might want to think about. These are all good committees for most nonprofits to have. The smaller nonprofits probably don't need all of them. But I do think a governance committee is something that every nonprofit should have, and a lawyer should always be on that committee. I said before, nominating, I think you should have annually. For the optics of fund sources, these are what they're expecting. The investment committee, they're going to expect us to have that. Okay, programs committee, it's not so much. Personnel, another big hot issue. I think very early on in the life of a nonprofit, I always talk to people about, nonprofits. We go through the mission and ministry approach at the nonprofit at the front end, where everybody knows the story, we all know the handshake, and we all figure we're doing the right thing. When we convert to an institution and we're going to survive, then immediately we have to start having these policies. It's a very hard transition for a lot of nonprofits. What do you mean? What do you mean we have to? Well, because as we're fiduciaries, we have to make that transition. We go from the mission and ministry to the institution model. This helps us make that transition, okay? We start saying, okay, we really ought to have a personnel committee at this point, okay? Even if we have just 2 employees or 1 employee, we ought to have something there that's going to define how we're going to deal with that person. Are they exempt? Are they non-exempt? All those questions you've already talked about. Executive committee, I think every nonprofit should declare itself an executive committee so that the primary officers and whoever else you want to include on it can act for the organization between meetings. That was quick. Helpful? Any questions at this point? Yeah.
Are you suggesting that counsel should be a member of any of those committees?
I think I'm not saying general counsel should. I think if a lawyer's on the board, it's a good idea for the lawyer to be on the governance committee. Okay?
But not general counsel.
No, well, I think general counsel would certainly be a resource for that committee, but doesn't necessarily have to sit on the committee, no. Yeah. And again, my understanding of what we're planning here is really, I call it outhouse general counsel. There's somebody that you can call up and say, hey, and really the resource I expect is going to be most valuable to the lawyer who's sitting on the board, who can say, okay, this has come up. I got this conflict of interest issue. I'm not happy giving advice on this. Can you help me with this? Hopefully it's going to be the executive director is going to be able to issue spot as well and say, I need a little bit of help. But that's the idea behind it. Personally, the 2 hot buttons for lawyers, I think, are governance and personnel. Those are the 2 places that we're most likely to get some calls and should get calls. The nominating thing should take care of itself if the bylaws are proper. The investment is, those other things. But in the documents that were attached, there are a number of things there I hope you'll find useful. I put a couple of the 990 EZ and things like that in there. And also a couple of the sections for 57-47 at SEC that will hopefully be helpful to you. The application for the solicitation permits there as well. So hopefully all that will be of use to you. And as we go along, I don't want to suggest that I know anything more than I've told you. But if something comes up and you're in the general counsel role and one of these questions we may have discussed should emerge for you, feel free to call. I'm happy to do that. I've happily had a lot of experience setting up a lot of small to medium-sized nonprofits and working with them over the years in Richmond. And it's great work. It's fun work. It is fairly easy to do the statutory maintenance, but it's very rewarding to for us as lawyers to be able to say, yeah, wow, they're out there because they're out there because, and they're doing well because. And particularly as they grow and mature as institutions, they need a little more of our help to keep management straight. When you're trying to make that move from everybody knows the story to we got to have some structure, that's really where I think we have the most value. So I'm going to step aside at this point. Thank you very much.
That was a lot of information. I'm going to discuss a couple soft IP issues, copyrights and trademarks, kind of give a primer. I don't have nearly as much nonprofit experience as Chris does, but I've seen some of these issues come up in dealing with nonprofits. So I'll jump right in here. Copyrights are a creature of federal law. What are they? They're something that's an original work of authorship that's fixed in any tangible medium of expression. We're not talking about ideas here. It's the book, not the title. If maybe a nonprofit has a publication it's putting out or is disseminating a video, that's something that should be on your radar that is invoking possible copyright implications. I'll go to the next one. The Copyright Act sets forth a series of things, typically for nonprofits that I've seen, when you have the development of things like websites, that's going to qualify. But if we just go through the list, what is a work of authorship? It's a literary work. It includes software, any software code that maybe an outside person is developing if they're setting up a program, musical works, dramatic works, pantomimes, choreographs works, pictures, graphic and sculptural works, sound recordings, motion pictures, architectural works. Anyone that's dealt with architects knows that they're pretty savvy about retaining their copyright for good reason. They want to be able to use it elsewhere. To the extent these works are being created, it's important that the organization gets its copyright ducks in a row, and I'll talk about that later with respect to the use of maybe independent contractors. Copyrights vest when they're created. Organization, to the extent it's engaged someone, the moment of creation means that there's a copyright, but that doesn't necessarily mean that it's enforceable. Currently, and there's a bit of a split in the circuits, but currently a copyright registration is still a good idea. So if you have a nonprofit that is creating, those types of works, it's possibly a good idea to go ahead and file a copyright registration. I put forth a couple forms in the packet of materials that can be used if you are inclined to do so in hard copy. The Copyright Office is out of the Library of Congress, which is unlike the Patent and Trademark Office, which is out of the Department of Congress. And the Library of Congress has recently just instituted electronic filing, much later than the PTO, but you can set up an account and go on and register the works. It's not a particularly expensive or hard process, but it may be a good idea to do so, because if you ever want to file a copyright infringement lawsuit, you're going to need to register it. There's, as I mentioned, a split in the circuits currently with respect to whether an application or a registration or an application suffices for the purposes of pursuing a copyright infringement suit. I would suggest that if you have something that the nonprofit thinks is valuable and worthy of registration, just go ahead and do it given the cost. Couple benefits of why registration is helpful. You get statutory damages set forth in the Copyright Act, and you get the registration certificate gives you the burden of proof if you do end up in a copyright action. The damages that I mentioned, you can get the license fee. In those cases, it's probably not going to be particularly significant, depending on the work, but statutory damages are available, and those range from $750,000 to $30,000, or if the infringement is willful, up to $150,000. One of the things that you want to be aware of is that secondary liability is a real concern. If your nonprofit's got a blog or something, they might be creating liability through contributory or vicarious liability. And I'll talk about that with respect to the Digital Millennium Copyright Act, but they might be creating liability even by facilitating an infringement. So, you want to be aware of that. Think here, Napster. I don't suggest that your nonprofits are probably doing that, but, you can create significant liability by facilitating a copyright infringement.
It can be done by a link.
Or a link, yeah, absolutely. One of the defenses to copyright infringement that a lot of nonprofits will bring up is that this is a non-commercial use, and that falls into the fair use doctrine, which is a factor test. It looks at 4 factors, really: the purpose and character of the use, whether it's a parody, whether it's educational, whether it's commercial or non-commercial, the nature of the copyrighted work, the amount of the work that's used, the effect on the potential market for the copyrighted work. This is, and I would caution to not rely on this. This is I don't want to say a coin toss, but it's varies very much from court to court, and I don't think you want to be in a position where you're relying on the fair use defense. So I would suggest if you are going to use something that is copyrighted, get the license. There are resources to do so. One of the items we talked about, or I'd like to talk about, is the work for hire doctrine. I think probably are familiar with it. If a work is developed in the scope of the author's employment, the employer is going to be considered the copyright owner. Where nonprofits get into trouble is thinking that applies to non-employees. I've seen organizations that still get the written assignment from an employee. I think it's a good idea to do so if there's a discrete work, or to have just a general assignment from them. But I'll talk about it as it applies to independent contractors. So as I mentioned, if the nonprofit has engaged a graphic designer or a videographer or photographer, and it wants to own the copyright, it's going to be important to get the copyright assignment from the creator. The work for hire is not going to apply, and you're also going to want to get a rep that whatever they've created is not infringing third-party IP. This can be a pretty short form assignment, but you want to make sure that whoever is creating things for your organization or assigning the rights that you think that you will own. Another area where I've seen nonprofits get into trouble is, and the internet has made this a lot easier, using third-party works without obtaining a valid license. And so you'll maybe be creating a website or a campaign, and you want an image of, I don't know, kids playing basketball, and maybe the assistant goes on and pulls an image off the internet. Well, sure enough, a year or two later, Getty Images comes calling, or Artist Defense comes calling, and they send you a license demand letter that they want a license fee for the use of that image. That can also work for music. There are resources that you can get these things if you know that they are using it. Creative Commons is one. If you're using music, just go get the license. You're going to probably get a discount for the fact that your use is in the realm of the nonprofit realm. I had a potential client or client get a letter recently, and the ignorance is not a defense here. You might not get willful claims, but you want to be, if they get this letter, these people usually don't go away. One of the other things you can look at is if they filed suit. That might give you a pretty good indication if you do a PACER search on them as to how whether they're all bark and no bite. But you want to be attentive to that, hopefully on the front end. I briefly mentioned the considerations for secondary liability, contributory and vicarious liability. One of the things that can create liability is if users are posting or storing materials on the website. That has implications for the nonprofit, and Congress, in its wisdom, came up with a workaround, provided that you comply. There's something called the Digital Millennium Copyright Act that provides safe harbor for online service providers for online copyright infringement if the online service provider does a few things, and that's they're acting as a passive data conduit. They're not going to be controlling the information that's posted. They're just merely allowing it to be posted. So if you have a blog or something, or maybe a photo stream, this is not going to apply to like third-party websites like Facebook or Twitter, but if your organization actually has that site, that can create an issue. They get the quote safe harbor if they have that passive ability, and then also have a policy of terminating the accounts of subscribers who are repeat offenders. And that's pretty easy to do. The way most people do that is by designating a copyright agent in their website terms of use. Do you mind hitting one more? That's all right. And so the copyright agent is someone that will receive claims of takedown notice. If you look at a host of websites, anything from YouTube to Dominion, you're going to see a designation of a copyright agent. That copyright agent, to get the safe harbor, needs to be registered with the Copyright Office. And I mentioned that the transition of the Library of Congress and the Copyright Office being late to the game. Well, they now are mandating electronic registration of a copyright agent, which needs to be done by the end of this year. So if the client previously had done it by paper, they need to go on and designate that person electronically before December 31st. Next topic I was going to talk about is trademarks. What is a trademark? It's a word, name, phrase, or symbol used to identify the origin of goods or services. Some examples. Exxon, people like to cite. I mentioned the NBC jingle just because it can be non-visual. A trademark doesn't have to be visual. And then one of the most famous in the nonprofit realm is, the Susan Komen pink ribbon, and they're pretty assertive about protecting that pink ribbon. In the U.S., trademarks accrue through use in conjunction with a good or service. They're going to be limited if you're relying on your common law use, limited by the scope of the geographic use of the mark. Registration is an option, but the trademark does exist even if you haven't registered it. But registration can be a benefit. There's a state option through the SEC, which is cheaper. I think it's $30 a class of good or service, and then at the federal level, there's a couple different levels. You pay at both the state and the federal level. You pay per class of good per number of classes. So at the federal, I think it's $325 if you're communicating by paper, $275 if you agree to accept electronic correspondence from the PTO, and then $225 if you use the USPTO acceptable goods descriptions that they've already vetted and approved. But you're going to pay per class. So, if your organization's talking about, hey, we want to have a T-shirt and educational services and, I don't know, a beer. I don't know what nonprofit that is, but let's just assume that for a second. That's going to be 3 different classes. So you're already talking about, nearly $900 in fees if you do it at the federal level. So you want to make sure that they're, really registering a brand in an area that they want to protect. An area where people can get into trouble is failing to do any sort of due diligence before adopting a name. Whether it's an organization name or a campaign, a fundraising campaign, to try and prevent that, you should do some sort of pre-clearance, recognizing the limitation of funds. There are different levels you can do. You can do just a knockout search at the PTO. And some internet searching. There are a series of third-party companies that do search reports that typically trademark attorneys review. They're a bit more comprehensive, or substantially more comprehensive actually, because they look not only at the federal and state registrations, they also look at common law marks like domain names, business names, website hits. There is some cost involved there as well. I believe that the reports, the 2 companies probably that do it the most are Walters Clore and Thompson CompuMark. The CompuMark reports tend to be around $700 or $800. So cheaper than an infringement suit, but if your organization's investing the time to put money into a brand, this is something that they should consider vetting before. There are 2 types of federal applications. Either way, you need to show use before you can register. There's a use-based and an intent-to-use application. I mentioned that you pay per class of goods and services. But the ITU application is helpful because you can show use on the back end. So if you're considering doing it, provided you have the bona fide intent to use the mark in commerce, maybe this is something you're considering down the road. You can't show use now, but if you go through the process, which if you flip and you can show use on the back end, down here, you're going to have to file a specimen after you pass these other things, but you can extend that out quite a ways. You get up to 5 6-month extensions, so you can pay to play, but it gives you almost a 5-year window if you're submitting an ITU to essentially lock up the brand name or the trademark on the PTO registry, and you get the constructive date of first use, that date that you applied to establish priority against the other applications and users. So that's helpful. Just going back, if you do file at the federal level, you're going to be examined by an examining attorney for both substantive and procedural issues, including likelihood of confusion, descriptiveness. A lot of times, clients will come up with descriptive marks that basically merely describe the underlying goods or services. You want to be wary of that because those might not be eligible for trademark protection. You're likely to end up a crowded field because everyone wants to name them. I don't know, Atlantic Charity or Virginia Charity. That's probably not going to be registrable. They'll also look at the goods and services description to make sure you paid them enough, claimed enough classes, that shouldn't be, in multiple classes. If you do get by the examination procedure, you're going to be published in the PTO official gazette for possible third-party opposition. It's a 30-day window where third parties can file notice of opposition or extension of time to oppose. If you get to that point, certainly you want to call trademark counsel, but that is essentially going to be, if you do end up not entering into some sort of consent or coexistence agreement with the potential opposer, you're in litigation before the TTAB, which is the Trial, Trademark, and Appeal Board at the PTO. And as I mentioned, if you make it through the opposition period and you did have an ITU application, you're then going to need to show use on the back end. Just setting forth here the factors that are used at the TTAB and in the Fourth Circuit with respect to likelihood of confusion. I'd like to say that lawyers tend to make things more complicated than they are, but they've created a 13-factor test to show you whether you think two things look alike or are going to come from the same source. 9 factors here in the Fourth Circuit. The other kind of substantive issue that an examiner will raise is descriptiveness. I mentioned that you have both descriptiveness of the quality of the goods or services. Geographic descriptiveness is another fairly common issue that comes up with marks. There is something called acquired distinctiveness, which you can claim under Section 2F of the Lanham Act if you've been using something, a mark, for more than 5 years, and it's created secondary meaning in the marketplace. But in general, I would encourage to avoid descriptive marks if they're doing it and they're trying to seek to carve out that area or that mark. Federal registration gives the registrant numerous benefits. Obviously, that coveted R symbol. You'll see that even with respect on logos. You get presumptions in litigation regarding the date of first use, as well as the presumption that you have the exclusive right to use it in goods. You can apply before use. I mentioned that if your organization is thinking about doing a campaign or something down the road, and they have the bona fide intent to do so, You can get that constructive date of first use if you submit an application on an ITU basis. You're going to prevent others from registering confusingly similar marks. And if the nonprofit is going to expand, I know Chris was talking about, mostly small, medium-sized nonprofits, but if there is the possibility that they're going cross-border, there are treaties like the Madrid Protocol that gives priority in other jurisdictions based on a filing date. So your organization has gone through the time and spent the money to get the mark, and one of the downfalls is you get any piece of property and you don't police it for trespassers. That can mean you lose your trademark rights. So if the organization has taken the steps to go and do that, it's strongly recommended that you engage a monitoring services. Again, the same companies that do the search reports will create monitoring reports that itemize confusingly similar marks or potentially confusingly similar marks. That's something that you're going to want to do, and the nonprofit, they can review that and flag it if they're sensitive to, maybe the cost of paying a lawyer, or even if you're doing it on an ad hoc basis. These reports themselves are not particularly cumbersome to review. They might refer you to a domain name or newly applied mark. But if you don't do that, you risk essentially losing the mark, because you're going to end up with a crowded field of similar marks, and they might usurp your exclusive right, and then the registration is pretty much worthless. So that's something that's pretty well recommended. Chris mentioned this regarding trademarks and a trade name. Trade name, the name under which a company does business, those can be registered with the FCC. Trademark, we talked about, identifies a designator of the origin of goods or services. A lot of times these two things can be the same, but if you're contracting under a trade name, under a mark, you're going to want to register it as a trade name. If you're raising money, even if it's a mark, you're going to still want to register it with the SEC as a trade name. It's just a distinction that a lot of times will get lost. You'll hear clients say, "Oh, I have a DBA." Well, you don't have a trademark. Or if you have a trademark, you don't necessarily have a DBA. The last thing I was going to talk about is the right of publicity, which Virginia statute provides that an individual essentially has the right to control their name, likeness, and image. It's limited to commercial uses. I think if you're using anyone's image or name to fundraise, this is going to be triggered. This applies to folks that have deceased and would go to 20 years after their death. And it's not just celebrities, although certainly I'm sure if you were to use a celebrity's image to fundraise, you're going to hear from their lawyer. It's going to apply to everyone. So, if you're using pictures of people from events and you want to put them in your publication, it's really a good idea to get their permission to do so. I've seen where people will try and maybe, take pictures of people but not show their faces, or, if it's just a picture of the thing, the event itself. But bottom line is that there's statute that protects people's right in their name, image, and likeness, and if you're using it, you want to be getting permission. That's about all I have. You guys have any questions?
Because I've had a little more experience with these issues with nonprofits, I'll share a couple of war stories from this. One fun one that happened some years ago actually happened out of a political campaign. In a statewide campaign here. they had a rally. They took a picture at the rally. They thought they had secured appropriate permission from those in the picture who attended the rally to use their image, but they used that image in connection with an advertisement that related to a very controversial social issue, and they got sued big time. So, a way to say, when we have our nonprofits, we're fond of trying to take pictures of our constituents, the people receiving our services, things like that. For God's sake, we have to have a consent to use those photographs. Event consents, if you're going to be taking pictures at your annual meeting and you're going to use it in media, again, we really do need to get consents from people who may have attended. And the statute is unforgiving in terms of the rights that under Virginia law you have for unauthorized use of your likeness. So I raised that. While I was sitting there thinking, I went back to the auction question that Walter had raised. And one of the things about auctions that's also interesting is the IRS reporting on that. If somebody comes and buys something at the auction and they pay $500 for it, what is their donation and what is not the donation? It's an interesting question because the person who donated that item is usually going to say, well, it was worth $250, so I want a $250 gift receipt from you. And then the person who buys at the auction, well, can they take a $500 one? No, not likely. So there's some accounting there. And how do you protect against that? You just establish the minimum bid on your auction item. Make sure that that's published, and then you just tell people you can take a deduction for the amount you pay over the minimum bid. That minimum bid has to have some real relationship to the value of the item. And I meant to mention that earlier, so I just thought I'd hit that quickly. In terms of the name issues, in Richmond, there is a nonprofit that I worked with. It adopted an assumed name that was important to the type of work they were doing. Fortunately, we had it. Fortunately, we decided to do just at least a state trademark. And lo and behold, a business in Richmond decided that they had this great new idea, and they used exactly the same name. Because we had done both those things, we shut them down in about 10 minutes. They couldn't use our name. And it would have been of value to them because it's an important, this nonprofit's doing important work in Richmond, and these people were trading off our trade name, which related to a particular service that we provided in the community, and they just adopted it. And it had valuable meaning for them in the commerce they wanted to engage in, but we were able to say, guys, not so much. And we were, because of the protections we had, and we just had state registration there. But state registration, both with the assumed name and the trademark, gave us a very easy swing to say, okay, don't do that. Those are just a couple of add-ons I had. Allie? Oh, I'm sorry, last, any questions at this point from anybody on anything we've talked about? If not, we'll go to Allie. Thank you.
And I'm going to go through Justice Server just to give you acclimation to the product so that when you're getting matched with your nonprofit clients, you'll understand what you're looking at. First of all, how many people in here are registered on Justice Server so I know what kind of audience I have? 3, 4, great. So Justice Server, what is it? Really quickly. It is a project we have been working on since 2012 with legal aid, and the real idea of it is to connect legal aid cases to volunteers. We, as a nonprofit that do pro bono service, have been lucky enough to be a participant in this project to help them look at how does this product help them manage their own business and how can we help volunteers get to pro bono service easier. And so what we are going to be doing in the next month or so is matching our volunteers, you guys who accept the engagement, to our nonprofits through Justice Server. So the idea is that it's a confidentially protected portal. It allows us to communicate with you. It's going to also allow you guys to communicate with each other. In your cases, your matches with your clients, you're going to have links to the resources, a lot of the materials you've gotten at these different trainings. That way you can have it all in one nice place. We'll put all of the materials you've received, the PowerPoints. It's going to be a really nice resource, I think, for you. Whether or not you'd use it as kind of your updated case management of your handling, that's up to you guys. But we would like, at the very end of your engagement, some kind of understanding of what time you put into this. So anyway, we have been working with Central Virginia Legal Aid Society, Legal Aid Justice Center, and we have built this, and it is now live. Next slide. Thanks. Just go ahead and keep hitting it until this is, okay. That's good. So In general, you may use it if you do other cases for legal aid, but I just wanted to highlight a couple of things that you'll be seeing. When you sign in, there's going to be an all cases opportunity. You can look at kind of the high level what is being requested for service. And you're going to have a specifically logged in place where your cases will be, and that's where we will be sending your matches. But this one is going to allow you to get notified if other opportunities are coming up. So say that your nonprofit engagement is not all, you have more time, you want more pro bono service, you can notify yourself of other cases that come up. If we have cases that come from this nonprofit general counsel program that need actual specific advice that's maybe in your practice area, we can alert you this way as well. So you're able to manage email subscriptions. It also allows you to do time, and for those of you who don't already have this, it has a stopwatch so you can do while you're on the phone call with your nonprofit, track your time. Next, thanks. This is just the home page, and I noticed the red arrow is just letting you know this is what everyone sees, very high level information, but there's a login button on the right. Okay, next one. If you have not registered, you're going to go through very similar to every other registration you've done in your entire lifetime, so it's not too complicated. There are a few things that we're asking for that you might not do on another website, and this is just in order to understand where you're coming from as a volunteer. So we're going to get your basic contact information, your experience. We're kind of asking, how long have you been in practice? What other practice areas do you do? Your bar license, we obviously need to know that. And then there's an other, and I'll highlight that. So right where this big arrow is a little section, and it kind of says, tell us why you're registering. What other areas are you interested? I would love for everyone in this room to put interested in the general counsel program, so we kind of flag you for that. And if you have any particular areas of volunteerism that you're interested in, even if it's a mission of a nonprofit, go ahead and just throw that into that place. All right, so once you've registered, you're gonna have your own password. It's, again, like the basic online. So next. When you log in, you're going to have just a slightly different, and some people don't catch this, but it's a slightly different selection up at the top right. Instead of just all cases and contact us, you're going to have my cases and your profile, and your the data basics lineup is just your login name. So this is what you're going to see when you go to my cases. There are different stages of case handling. So when you first get your assignment, we're going to ask you to check it out, and then you're going to do a conflict check, make sure that you can do this engagement. And so the top right here says pending conflict check, and we give everyone 72 hours to do their conflict check. It has a little timer. It's going to let you know how much is longer until you are going to have that case clicked from you. Pending acceptance, we had a secondary stage. So you clear the conflicts, but once you look at all the inner details of a case, sometimes that's where you see you have the conflict. You didn't realize there was some kind of extra party that wasn't mentioned at the high level. So anyway, we gave you one more bite of the apple there. And then this green section is where your accepted cases. So if you do this nonprofit assignment with us, that's where your client will be. But if you also do a wills clinic, or if you do something with legal aid, that's where those things will be as well. This is pretty much the same thing. If you were to reject the nonprofit assignment, it would just go back to the queue, and it would say rejected in your list view. All right, so this is the conflict check. I just wanted to kind of show you what it looks like. Yours is going to say something like nonprofit in City of Richmond, and it would have location, Greater Richmond Bar Foundation. Case category, it's going to say, corporate governance. And then client would have the name of the actual nonprofit plus the contact of the executive director. There won't be any adverse parties. And it just gives you an opportunity to kind of copy that to a clipboard and send it off to your conflicts person. All right, so once you're actually accepted a case, this is just kind of giving you an actual idea of what you're going to see. You're going to have basic information up here at the top about the nonprofit. Case details will be very basic. This is where you could add notes. And to the right talks about closing your case, important dates. These are all things you can use or not use, but this is, if we know about anything, we put it in there. And then hours right here. To add a case note, you put new note, and then you just can enter whatever you'd like. I usually, when I'm using the system, just put a quick date, talk to client, brief reminder, but you literally, I know you all have case management systems, so. Attachment, you can attach anything. We will attach any documents we've received in our application so that you'll have bylaws, articles, all that kind of stuff, or a link to their page on, help me out, GuideStar, what is it called again? Yeah, it's a different word, but I can't remember. Anyway, and that's the basic there. Add attachment, you can literally add anything from your computer. It'll upload it there. Next. Thanks. All right, that's it. So we're going to be sending, we have a list of the nonprofits you heard in the beginning, and we are going to be sending a survey to all of you, hopefully before Thanksgiving, so that we can kind of get your interest. Are there specific of the topics that you've learned about that you would like to not really see again? Are there ones that you feel very comfortable in handling, so we can kind of understand where we need to partner people with mentors? Also, if there are certain missions that you're interested in serving, we'd like to go ahead and gather that and have the most meaningful matching process we can. We hope to, Mike, what do you think? We're hoping to have the final selection of clients by the end of this month, and hopefully notify everyone of an offer. We have worked very hard on a meaningful engagement letter sample for you guys to use with the nonprofits. We have an expectation letter of your relationship with the Greater Richmond Bar Foundation as a volunteer, and also we'll let you see what we're giving the nonprofits as the expectation for them. We've tried to really limit their expectations so that they're not getting a beck and call volunteer that they just, every legal issue call you. So we really are excited to launch this pilot, and we really appreciate your time. So, thanks.